Hey everyone. Oh my goodness. Shout out to everybody in the chat. Hopefully you guys can hear me. Can I hear me? Okay, I hear the mic. Shout out to everybody. Let me make sure that I think I'm situated right. Ooh, this light. 1 second, y'all. Right when I think I'm ready to go and I'm not. Shout out to everybody coming through. Make sure you guys are hitting that like button. Thank you so much for being here. Shout out to everybody. I got some members in the house that have some anniversary. Sinner, thank you so much for being a member for 1 month. And Brianna, I know you've been a member longer though, Sinner. You must have renewed. Shout out to you. Brianna, thank you so much for your 1 month member. You've been a member before as well. So I know it's probably just a renewal. Okay, crime news. It also says 1 month, but I'm pretty sure this is a renewal for you too, because I think I've seen you as a member before. Shout out to everybody. Oh my God. We're going to get it together. Fairy Dust Diaries. I almost said Fairy Dust Us. Fairy Dust Diaries. Thank you for being a member for 3 months. Shout out to you. Thank you, thank you, thank you. We are gonna get into it. But what I realize is I know I've been leaving a lot of subliminals on my like community walls, and it wasn't like hmm, I haven't put a lot of names, but people that are in the true crime community can definitely pick up what I've been talking about, right? So I don't feel like I have to do a whole lot of explaining, but I still will be kind of giving you guys a good little um a good little breakdown. Blank Screen, who's been a member for 6 months. Shout out to Blank Screen, man. Shout out to Blank Screen. Just being petty for highlighting this. LOL. Shout out to Blank Screen. And Linda as well, who's been a member for 1 month. Oh my God. Y'all don't make me lose it, okay? Shout out to my mods. Shout out to everybody coming through. Listen, we're going to get right into it because I had quite the read today. Now, let me give you guys a little summary for those that don't know what is going on. In the true crime community, we have a current lawsuit that is going on with two creators. One of those creators is called Bullhorn Betty, and then the other one is QueenBee. In this lawsuit, QueenBee has decided to countersuit, which she did. And I think she's been able to raise some funds with the support of the community. Please note that her Cash App is pinned in the description. Well, it's in the description box as well as in the chat for you guys to check out. You're highlighting mines and for Blink ADAS. Y'all stop the petty. Stop the petty. All right? Hoping for answers. Welcome. Thank you for being a member. Okay, let's get it together. So if you guys can support, please continue to do so. It's right there. It's for her legal expenses. Let's talk a little bit about some of the motions that were submitted by BHB. Okay. Now, in those motions, my channel was mentioned as someone who broke the news, and somehow conspired with, you want to be petty too, Miss Sleep? Shout out to Miss Sleep for a 3 month membership. She said, I want to be petty too, damn it. I'll be petty too. Yes. Okay. Oh, Grandma Sherry too. Okay. And if you guys can help Grandma Sherry, I know she's going through some stuff right now. If a mod can share her Cash App, please and thank you. Don't feel, everybody. Please note that everybody's got different financial issues. Don't feel like you're obligated, but whatever you can do, if you can help, please help. You know what I'm saying? We're still people at the end of the day. All right. We still got to look out for each other. This is a community and y'all make the difference and you guys help everybody out. So thank you. J Dub has been a member for 5 months. Who else became a member? True Jedi Forever. Thank you for becoming a member. Oh my God, y'all. All right. I need to finish some sentences here. What's the Cash App? Oh, let me see. Can you, Grandma Sherry, can you I know I did Cash App her yesterday. Grandma Sherry, can you reach out to Peekaboo maybe or Chico or SW and one of the mods in the Discord and just give her your Cash App? Please and thank you. Yes, absolutely, Grandma. I don't know if you can drop it in the chat. I don't know if anybody can help her out. But yeah. Thank you. Yes, this is the Cash App right there. Anything helps. If you have $1, $5, $10, whatever you guys want to support. And yes, thank you. All right, let's get it together. We got to get into this. I got to get right to it because we got some docs to read. Okay. So my channel was mentioned in Bullhorn Betty's motions to, what is it? Which one was it? The protection order that she was asking be granted. The way in which it was written, it was like, I broke the news. No, I didn't break the news about this lawsuit. No, I did not. It concerns me that somebody, thank you, Jane. Shout out to the plaintiffs, Jane. Thank you. It concerns me that somebody who um, is out here advocating for victims, that you would willfully misinform the court about who actually submitted those, who actually broke the news. It was actually her friend, the other blogger, what's his name? The one that sells shampoo or soap, Paul Mitchell, whatever the hell his name is, I don't know. The turtle guy, that one. Um, Look, it really does. Let me stop right there. Why the fuck did I say Paul Mitchell? What? Let me stop. All right. All right. Let me stop. Okay. The, I don't know why I said Paul Mitchell, and I like Paul Mitchell products. Okay, let me stop. All right. So it was that guy broke the news about the lawsuit. She was in the chat. She acknowledged it. I don't know why she put my channel name in these documents. I'm just saying, I don't know why. So I was like, well, that's just awkward. And yet again, like, to willfully do that, because you have to write those documents. Why would you put somebody else's who did not break the news about this lawsuit and then try to even insinuate that somehow that, we're acquaintances, yeah, we're on YouTube. We all, you know what I'm saying, talk to each other here and there and everything, but nobody's conspiring to do anything to this woman. I found that to be distasteful and very much concerning for someone who presents themselves to be truthful for victims, buying flyers and whatnot for people. Part of me too, I want to start with this little spiel. Like, I felt a little bit bad because I did see this one video where she was upset crying because she was getting trolled. I'm not really sure what the hell it was going on with her in that situation. And I was like, well, damn, like, there are times where we could really use somebody with advocacy skills to advocate for people. I felt bad for her for a minute, just for a minute. And then it went away quickly because it's the continued, I guess, arrogance of the her attitude that I couldn't really understand. Yeah, wasn't she crying because something about flyers? She bought flyers for somebody, and she was blaming the glare for something about the. I was like, "What the fuck is going on?" And I was sitting there and I was just eating my food, but I was sitting there and I was trying to figure out what the hell's going on. She was crying or something. That's what I was like. Anyways, and then that went away. That feeling of feeling bad for her actually went away fairly quickly, after really understanding what she was saying in these documents, in the motion to strike, and these protection orders, and all that other stuff. I'm just saying it's a lot of entitlement. But what was even more interesting is that in the review, shout out to Burnt Toast and Menace to Sobriety, those two channels, because they did a really good breakdown of those documents. Menace did a couple of, lot, or what is it, uploads, and did a little bit of a breakdown. And then Burnt Toast really went through it. And I actually put their names in the description box so you guys can check them out. You guys know we love those channels over here. Cool channels. And one thing that Burnt Toast, it just really stuck out to me. And I was like, yeah, I got to be mindful of that. I am not here to, review documents to give anybody hints or tips on how to do stuff. I do have a lot of attorney friends, thank God. I do know, so I have some legal resources and stuff like that. I do. However, I'm just, I don't know everything the law. I'm just reading a couple things and just giving some commentary to here and there stuff. That's all I'm doing with this. Nobody's getting legal advice from me because I couldn't give it to you. So that being said, though, I just found that to be very distasteful. I also saw that her friends, I guess she decided to, she basically, in one of the motions, she decided to say, well, Queen Bee can't countersue because you're not adding all the people to the lawsuit. And I was sitting there and I was like, wait a minute, what does she mean adding all the people to the lawsuit? So she wants several other folks added to this lawsuit. And I kind of felt like, well, damn, tell me about your friends. Because if I had a friend, and I shout out to the plaintiff's Jane, I have a lot of, great people here in the chat that I consider friends as well. If I have a friend and they decide to put me in a lawsuit and I don't even know about it, okay, let alone like, is that what, you know, is that what y'all wanted me to do? Like, I just didn't understand that piece. Like, did you consult with them? Did you not? Suddenly they're being added and they don't even like either agree with it or know about it. And then I'm finding out that you're given an opportunity to settle and work through that difficult situation with the attorney before it even escalates, and it's declined. I was like, I cannot. Yeah, man. And let me tell, I'm not a fan. I'm not a fan of the friends. I never done anything to the candle wax lady. Never did anything to her. She came for my neck, so I was like, cool. When you come for my neck for no reason, you stay over there, candle wax lady, grenade lady. You stay over there. Go pop over there with your damn self. But I did hear that the grenade candle lady got upset too and was also saying how stupid BHB was. And I said, "Oh my god." I mean, somebody's got to give some sense to something. I'm glad that they saw that. Um, I heard some of that commentary and I was like, yeah, cool. Uh, um, at least some people have some sense. And then the other lady who has a vendetta with me as well also denounced her. And I'm not saying her name because I don't want to give clout to, people that aren't, in this app anymore. But anyways, so I just couldn't do it. I can't. Lord, listen, I have nicknames for folks. That's what I do. I don't say names because I don't give you flowers unless I have to, and I'm good. Anyways, let's get into these documents. Are you guys ready for these documents? You're going to need to clutch your pearls on various documents that we're about to read. So what I did is I actually was able to pull them as a regular Google Doc, which then allowed me to word replace certain things here. So things have been redacted, of course, things have been edited. These are documents that are available, in public record and such court, websites and whatnot. You make sure you guys check those out if you're wanting a more individual type of read. Okay, let's get it together. Let me get my drink. We got some reading to do. Woo. Okay. And let me, I promise you, I'll check the super chats here in a minute. I know I missed some. Shout out to everybody coming through. If you're just coming through, please hit that like button. It helps in the algorithm. Let's do some reading, okay? Let's do some reading. This is QueenBee's attorney responding back to the motions that were submitted by BHB, and you guys are going to find these very interesting. I suggest that everybody needs to sit down and read, okay? Just read. So it says QB through counsel at lawyers respond to BHB's motion to strike. QB's notice and demand for bill of particulars motion as follow. So if you guys remember, the attorney, QueenBee's attorney, is saying we need a bill of particulars. BHB said, no, we need to strike the bill of particulars. She gave, I think, a 9-page response to why it needed to be struck and why it wasn't necessary, and why, other people needed to be sued in this, and all kinds of stuff. Now the attorney's going to respond to this, to BHB as well. Clutch your pearls, okay? Because this is big. Introduction. BHB provides no reason to strike the notice and demand for bills of particulars, and this court should not do so. A bill of particulars would rein in this wide-ranging case by narrowing the issue. In doing so, it will allow the parties to proceed efficiently and at a lower cost, and Queen is entitled to a bill of particulars. in her procedural improper motion to strike, asserts the notice and demand is nonsense and littered, not literal, littered with foolish, insolent talk. Ooh. And he says BHB uses 9 pages to, number one, defend herself. Number two, disparage a reporter, which she did when she spoke about the Vanity Fair reporter who did an article. Number three, attack Queen for no apparent reason as it relates to the notice and demand or the motion. Number four, incorrectly raise evidentiary issues at a non-evidentiary stage of the case. And number five, attacked undersigned because undersigned firmly but hardly overzealously, let alone unprofessionally advised her of Queen's position. Now, undersigned, for those that don't understand, that is the attorney. Okay? Keep that in mind. What is notably absent from this list is any reason the notice and demand for bill of particulars should be stricken. That is because there is no good reason and the motion should be denied. Ryan, welcome. The motion should be denied as procedurally improper, even if this court elects to, if construed as a motion under, and there's the number, it fails because BHB complaint is in disarray, makes no firm allegations, is unclear, and Queen simply cannot respond to it. A bill of particulars is necessary to advance this case in any reasonable fashion. As for the rest of BHB's filing, it is unwarranted and unnecessary for resolution of the motion, but it is briefly responded to as it is problematic. They give us the history, okay, of kind of where we're at. So relevant factual and procedural history. BHB sued Queen in June 13th of 2023. After being served, Queen hired undersigned. Remember, undersigned is the attorney. Undersigned promptly sent BHB a letter explaining the lack of factual and legal merit in this complaint. BHB took great offense to the same, called undersigned unprofessional for his advocacy, and threatened disciplinary proceedings. See motion to strike Queen's motion and demand for bill of particulars. BHB, not Queen, filed the firm, but reasonable letter along with her uncivil emails in response. It is notable because the letter provided her the opportunity to dismiss the case before it escalated, and she's out herself as someone who threatens disciplinary proceedings to gain an advantage in a civil proceeding. Where she's an attorney, she would be violating Illinois rule of professional conduct. So if BHB was an attorney and she's threatening to, say like you're being unprofessional, what was the word? What was it? Your professionalism or unprofessionalism is disgusting or some shit like that. I swear that Burnt Toast played that video and that shit kind of played in my head over and over and over. If she was playing this game and she's an attorney and they're both attorneys, somebody would be in trouble here, right? Just because you're filing pro se doesn't mean, right? You're filing on your own doesn't mean that you don't get to conduct yourself in some manner of professionalism. You have to. I don't know. Some of us watch a lot of court TV. What is it? Law and Order. And, we think that somehow attorneys always fight and that's how they don't get along. That's not true. Great attorneys actually work together to find resolutions because they have to. Does she? Listen, this response right here was like, look, sit down and eat your food. That's what this response was. This lawyer shows no. And honestly, he doesn't have to, right? Good day. He's like the consequences of Bullhorn actions are personified. Right. He doesn't have to he doesn't have to be nice, right? Like this is not like, hey, let's get together and let's have a, a tea party. No. No, 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 no. And like I said, I think that the community, folks were asking me, Rabbi, you got to review this. And absolutely, I wanted to. I just haven't had time. But the community is invested here because so many people donated, right? We want to see a good outcome. We want to see a good attorney do a good job. And I think that this attorney is handling himself as he should. If you're coming for me and you're threatening me, I don't care if you filed pro se and you're representing yourself, you're threatening me this way and I got a law license, I'm gonna mop the floor with you too. You know what I'm saying? Like, you don't do that. And this is what he's trying to tell everybody. You don't, if you were an attorney, it would be equal. You would be in trouble for doing that. And if you know the law, then act like you do, right? Plain and simple. Plain and simple. Not law school. Stop, sinner. Mm-mm-mm. Yeah. Yeah, it's a great attorney. I mean, listen, these are great. This is great motions that are being filed. Opportunities to work with this person to, meet her halfway. I don't think she wants to. At least that's not the language that she's given. So I guess we'll see where this goes, right? So where did we leave off at? After Queen made her intention to proceed clear, BHP began her defense of the case. She prepared and filed a notice and demand for bill of particulars because a complaint was in disarray. At the same time, Queen filed her counterclaim against BHP. She has since served discovery on BHP, the subject of a to be filed motion to compel. On August 15th, 2023, BHP filed a flurry of documents. She moved to strike the notice and demand for bill of particulars, moved to appear telephonically, moved to dismiss the counterclaims, issued a request for production, and filed the motion. Excuse me, hold up, and filed the motion began respond to. I think there's a word that cut off there, or maybe I'm reading this wrong. And filed the motion began to respond. Begin to respond to. Gotcha. Yes. So basically, this is what she did. She moved to strike, okay, the bill of particulars, and then moved to appear on. So then she filed that motion to appear via Zoom or telephone or whatever, and then moved to dismiss the counterclaims. Okay, that's basically her moves. The same day, the lawyer explained that the bar on discussing with her would make the litigation process harder. The same day, undersigned explained that the bar on discussing with her would make the litigation process harder. They are giving exhibits here. Exhibit 2, her response was to state that she would only discuss if Queen stipulated to relief sought by BHP. Now, is that financial relief? Is that, like, are you saying I'm only going to do this if BHP if Queen pays this much? I'm only going to do this if is that what she I didn't quite understand what was her thought. Let me tell you something. I don't know about you guys, but to me, if I was in Betty's position, I don't know, I would have taken the opportunity to settle something. You know what? I'll drop this. Maybe I'm way over my head. Okay. Like, humble yourself. Humble yourself. If you believe in God, okay, then there's somewhere in that Bible or somewhere in the stuff that you listen in those Sundays, whatever. It would have been like, humble yourself, child. Okay. You're way over your head right now. You have to let go of that ego. I don't know. Some of that. You have to let that go. I would have like talked to the attorney. I would have probably even requested to speak with QueenBee and said, QueenBee, I know you don't like me. Okay, can we come to a middle? You don't do videos about me. We don't talk about each other. QueenBee, can we figure this out? Shit, listen, as somebody who I think is considered a roach, by BHB. If her friends are listening, y'all, I don't. If you guys can email the attorney, if she can email the attorney, say, attorney, would you be willing to like let it go? Okay, like the movie Frozen, let it go. Something, something behind the door. I don't know the fucking song. Sorry. I'm about to because I did watch it. Shout out to Baby Bunny. Something, right? Something. The art of negotiation, the art of war. Got to learn how to make those two work. Sometimes having a big ego can really fuck you over if you're not careful. You know? You know what I'm saying? All right. She wants nothing to do with the attorney. I wouldn't want anything to do with the attorney, so I would do whatever I can to make him go away. Sure, I will definitely talk to him and some type of mediation with QueenBee so that we can come to a common ground. QueenBee is not going to make any more videos about me. If that's all she wanted, that's it. That's all. But hey, you know what? Let's proceed. Okay. So it seems argument. It is not a procedural vehicle for striking a notice and demand for bill of particulars. It seems BHB or those potentially assisting her. Now this is where it's going to get good. Y'all ready for this one? It seems BHB or those potentially assisting her have enough knowledge of the legal system to put together filings in a way that looks good to the lay public. All the same, they lack sufficient knowledge to follow the rules that allow for the efficient administration of justice. Here, BHB seeks to use, 2-615 of the rules to strike a non-pleading, a notice and demand for a bill of particulars. BHB acknowledges motions to strike as disfavored. More importantly, a motion is directed at pleading, not for demands for bills of particular. Thus, the motion is procedurally improper and should be denied out of hand. The rules apply to pro se litigants as much as they do to those that have represented litigants. Hold up. I love this right here. And let me highlight that, okay? Because I got a little highlighter right here. The rules apply to pro se litigants as much as they do to represented litigants, which means the rules that this attorney has to follow apply to you. They apply to everybody else. They apply to those that pretend to play attorneys on YouTube. They apply to anybody that actually helped fix this paperwork. They did. They do. They do. I like that right there. I like that highlighted. So then he cites a case that should be all the more the case for BHB, who trumpets her legal knowledge and skills, is suing as part of a business dispute and refuses to make the process easier with discussion outside of the filings. Supra. Even if the filings were a motion under 2-607, it would fail because lashing out an emotion does not explain how the complaint is truly adequate. The rules of civil procedure allows the defendant to seek a bill of particulars when a complaint lacks sufficient details. The defendant, which means that it means that QueenBee is allowed a bill of, she's allowed to know the why about why you're suing her. If we're being sued, we are allowed to know, and if it's confusing, we are allowed, trumpets, not Trump. My bad. Did I misread the word? See, I need my glasses. Trumpets and I said trumpets. Did I say triumphs? See? Lord, y'all are correcting me. I should have said bullhorns over, right? Okay, what did I say? Hold up, let me go back. There it is. I said trumpets. No, trumpets was correct, right? I said trumpets, and y'all are throwing the bullhorn? She said, "Oh my God, y'all are like, I get it, trumpets, get it, trumpets and bullhorns." Stop, y'all ain't funny. Callie, Flor, tone it down a bit in the chat. What are you doing to me? Here I'm thinking, I'm like, wait, my glasses. No, it says that. I should have said, okay, that should all be the more the case for BHB who bullhorns her legal knowledge and skills. Oh, geez, there you go. Bullhorns her legal knowledge. I say, I don't know why the attorney wrote this. I don't know why he wrote trumpets. I was gonna say triumphs. Oh my God. Yeah, hit the damn like button. If I have 400 people here, I better see 400 likes. Mm-mm-mm. I was gonna say, what's he supposed to say? That she's loud? Oh man. Okay, let me stop. I thought I misread that. Well, now I know. Shit, I've been misreading things because I need to get my. I'm waiting on my damn something to put on my eyes because I've been seeing different things. She's blowing her own horn, basically. I don't know, Kim. I think he really meant to say that she's loud about her legal experience. That's what he's trying to say. And by the way, because I know this is going to happen, I know there's going to be some hater that's going to review this. I hope you get a good laugh too. You know what I'm saying? Shit, I'm not a hater. Okay? I'm not, I'm just, I love it because there's like the lady that her content is other people's content. So what she does is she reviews people. She's the one with the grenade lady. She's the one that has like people don't start shit with her and she starts shit with everybody else. That's what she does. I mean, I never start shit with her. She started shit with me. So she'll probably use this as a legal review. You know what I'm saying? And she'll give commentary to all of this because this is what she does. All right, let me stop. Yes, thank you, Good Egg. Look at Good Egg. It's basically like people who feel the need to loudly announce how amazing they are. Like, yes. No, I'm not a hater. I just crush a lot. All right, let me stop. Let's continue to read. Okay, so even if the filing were a motion under 2-607D, it would fail because lashing out in a motion does not explain how the complaint is truly adequate. The rules of civil procedure allows a defendant to seek a bill of particulars when a complaint lacks sufficient details. The defendant must identify defects complained of and the details desired. The notice and demand do just that. The complaint is incredibly vague, as identified by Queen in her notice and demand. BHB fails to explain how there is sufficient. Hold up. And that is likely because she cannot do so. Jeez. That I can't. Hold up. Wait, it's because this attorney. Oh my God. See, this is when it starts getting really, really, really spicy. Let me read that sentence again. Are you guys ready for this? Okay, let me go back. The complaint is incredibly vague, as identified by Queen in her notice and demand. BHB fails to explain how there's sufficient I can't even say the word specificity. Look at this. I got a little accent now because I've been laughing with y'all. It's spicy. So there's not sufficient information, basically. That is likely because she cannot do so. Did y'all see this? He said, that is likely, hold up, right here. That is likely because she cannot do so. That is likely because it is, at least in part, either lifted from, drafted by, or helped draft by her colleague, JLR. Okay. Let me. Oh, Lord. Does JLR know about this? I just wondering. Like, I just want to know. Like, he's mentioned here. He's mentioned. I didn't say it. Yo, JLR is mentioned in this lawsuit. Does he know about that? I mean, this attorney is saying that JLR, that he helped her draft. Okay. All right. So it says, or helped her draft by her colleague JLR in a similar suit he filed against individuals in Ross County, Ohio, about a month before BHB filed hers here. Exhibit 1, JLR complaints contains very similar allegations. Wow. So he just did a comparison of BHB and JLR's side by side. BHB complaint, defendant runs multiple YouTube channels and have repeatedly published defamatory statements about plaintiff on her QueenBee channels. JLR, defendant runs multiple channels and has repeatedly published defamatory statements about plaintiff on his channels Rock-A-Lot and Puny Rock Live. Defendants have published numerous false defamatory statements about plaintiff, accusing her of criminal activity, falsely portraying her work as a journalist, and attempting to humiliate and damage her reputation in the eyes of her subscribers and the public. Okay, and then JLR wrote, I guess, defendants have published numerous false and defamatory statements about plaintiff, accusing him of criminal activity, falsely portraying his work as a journalist, and attempting to humiliate and damage his reputation in the eyes of the public and his subscribers. Oh no! He did a side by side. 18. Defendant accused plaintiff of stalking, harassing, and pretending to report and troll so that she can make money off of unwitting people. Defendant accused plaintiff of stalking, harassing, and pretending to report and troll so he can make money off of unwitting people. Defendant defamed plaintiff by referring to her as a tragedy pimp. As defendant knowingly and falsely stated as a fact that plaintiff does not actually work for missing people and that plaintiff only harasses and breaks the law. JLR wrote, defendant defamed plaintiff by referring him as a tragedy pimp, as he knowingly and falsely stated as fact that plaintiff does not actually look for missing people and that his work is not actually reporting. This is, he says, examples of exact duplicates or small differences around the two filings. Man, it's not good. That beat him. Did you think he was cold? He did a side by side. Look at that. Like it's one thing to like, what in the motherfucking plagiarism is this? See, and that's not good. I mean, I think JLR is kind of minding his business, but if he's involved in this is not good. This is not good. You know? I don't know. I'm just saying it's like copy and paste versions of all the lawsuits. I'm just reading. Y'all don't come for my neck. I'm reading what it says. This attorney literally did a side by side of both filings, and this is what he came with. And then he mentions JLR attributes these statements to a direct quote from the defendant in the case. It is highly improbable that JLR's allegations, direct quotes from JLR's defendant, is the exact words that an unidentified defendant, whether Queen or her co-defendant in this case, said. Undersigned has also spoken with counsel for another person that BHB sought a restraining order against, similar to what BHB seeks against Queen. Here, the counsel conveys JLR was present at BHB's hearing and video recorded him. Oh my God, that BHB is working with JLR is hardly surprising, but efficiencies BHB might find in working with the man reportedly being the most litigious man in the world do not excuse pleading standards. Ultimately, Queen simply needs to know what she stands accused of. And that's really what the bill of particulars is. Like, what are you accusing this woman of? What are you accusing QueenBee of? And not everybody else. Not everybody else that sits on panel with her. No, QueenBee specifically. There is nothing plain and concise about BHB's complaint, as the notice and demand explains. BHB has not said that defendant did what all the more important, what is it now, that she is trying to dismiss Queen's co-defendant from the case. I believe they're speaking on heels here. There is no specific, I can never say this word. There's nothing specific, say it like that, about the supposedly harmful, whether defamatory to what is it? Tortiously interfering or emotionally harmful statements potentially because they are statements from JLR suit defendants Supra, and there is no agreement with YouTube LLC. So this is a good point. If QueenBee had made some statements, right? And they're the ones that are outlined in the complaint. If she copied and pasted from another complaint that was made by a different case, by JLR, whatever individual made it, are these truly BHB's complaints? Like you can't just use those complaints as somebody else wrote in a different case and copy and paste them to your complaint. You can't do that. Oh, really? Yeah, we can't say for what I'll just say specific. It's something about the too many C's. Shout out to Charlotte. Did she? See, I'm not the only one who had a hard time reading that. Just say specific. But that's a good question though. You know what I'm saying? Well, I mean, does he even know? Like, I don't know. Listen, I don't know. I don't know. This is not a good start though. I'm just saying, like, this is a real attorney. He's saying like you can't be saying how is this harmful to you when it's a copied and paste version, or at least it looks similar to somebody that has written something like this before, and then counsel or people have actually seen these two people go to court together and take pictures during some type of lawsuit of whatever else. I don't know. This is just what it's saying. BHB. Ooh, how do you say this word? Hold up. Let me look it up because I don't want to say it wrong. I feel like I had a note here somewhere. Hold up, hold up, hold up. Let's look it up because I want to see what this means too. Proclivity, a tendency to choose or do so. Oh, yeah, I know what the hell that meant. BHB proclivity. Oh, man. Hold up all these damn big words. Feigned. BHB proclivity and feign. Countenance. There it is. BHB proclivity for feign, outrage, and lashing out should not be countenance. Countenance. Lord, I just say the regular word. My goodness. Ooh, they quote someone here. You can disagree without being disagreeable. Interesting. BHB devotes pages 5 in part through 8 to attack Queen and undersigned counsel. Yeah, she did attack the attorney. BHB feigns outrage at a firm, but hardly overzealous letter sent to her. As a result of that communication, BHB states, I'm going to demand you to discontinue communication with me until we are before the judge to discuss this very matter. Ooh. She does so after seeming to hint at a disciplinary proceeding and sanction proceeding. Any attorney dealing with such a litigant would cease anything but necessary to communicate, but necessary communication with her. This outsized response to a simple notice to the court that undersigned was instructed not to speak to BHB seems less about any actual concern and more about YouTube commentators. Yeah, I would say so about that. Propensity. See, I was like, didn't say propensity. It's an easier word to say. Thank you, Center. Thank you for being my dictionary today. Um, I don't look smart when I say big words. I just say it in English. Say it in the English. Just say it. Say. I mean, I already have a trouble with the English language. Say it in more English, simpler English. Okay. Let's see. So she was more. So what he's saying is like she's more worried about YouTube commentators. I would say so. Undersigned has viewed at least one video by a commentator asserting they have purchased the filings from Tyler Technologies and criticizing BHP for doing so. Okay, that BHB's outrage feigned is quite apparent. Not only is the original letter appropriate, but the follow-up email to BHB's statement and the letter was defaming, defaming stated. I received your email. While I disagree with your conclusions, we know your intentions to persist and will proceed accordingly. As my letter, and to prevent misunderstandings causing you to file another suit, please note that under Illinois law, defamation requires a publication to a third party. Even if the letter contents were true, were not subject to litigation privilege, then it was still only sent to you. Thus, there is no basis for the claim. And I read the attorney letter and stuff. I didn't take that as a threat. I felt like he was saying, like, listen, under this law, which is where this is happening, um, like you probably want to consider, dropping this, or at least considering not like you have to understand that you don't really have a case here. I felt like it was a nice, paragraph. There's no basis for a claim, meaning you have no case here. In her response to this, your professionalism is disgusting. Oh, that's the word. Your professionalism is disgusting. That's what she said. I said, well, wait a minute. What would you have preferred him say? Like, what would you? This is it's a good letter. That BHB who promotes herself shouting, sometimes amplified through bullhorns at scenes associated with national tragedies, would be offended by the letter is preposterous. That BHB characterizes the response to her emails as unprofessional is neither a known lie. It's either a known lie or an indication that BHB believes any disagreement with her to be an insult. Ooh. Given prosecution of the suit and claims against another person critical of her. What is overzealous is threatening and sanctions and disciplinary proceedings, the latter of which would violate the rules of professional conduct if an attorney did so. That is so true. If BHB was an attorney and she was holding herself this way, the attorney would be like she would be in trouble. She would be sanctioned for that. So what he's saying, he's like, listen, if you have this trumpet of skills and you know the law, then you will know that your behavior when one attorney is trying to communicate with you in a professional, and I'd say it's professional, he's giving you the heads up. He didn't have to, but he's letting you know. And your skills are, they're trumpet in comparison to all these other attorneys, then, you work with the man, you work with the attorney, you know? Yes, thank you. This is just giving commentary. Just saying. All right, let's go ahead and keep going. Okay? Let's see. So, what is where did I leave off at? Okay, what is overzealous is threatening, sanction, and disciplinary proceedings, the latter of which would violate the rule of professional conduct if an attorney did so. What is over the line is quoting from a court recitation. Why am I know how to say this word. Lord have mercy. Hold up. Yeah, I said it right. Recitation. Why am I'm like trumping over my words? Trumping. Recitation of an opponent's characterization of a position as it if were the decision of the court. One need not be an attorney. Oh, I love this. To know what plaintiff contends that defendant and their counsel does not mean the court has determined anything. BHB lashing out does not change that she asked to not be communicated with while hinting at sanctions or disciplinary proceedings. Finally, as for any claim of being verbally combative, as it's suggested on page 6 of the motion, undersigned has never spoken to BHB. Litigation is contested adversary process. Positions are stated in advance. Sometimes positions are developed without the opponent's understanding the path being taken. Oh my God. See, I love this. See, he just said right here, interesting. Sometimes positions are developed without the opponent understanding the path being taken. Okay. Does she understand the path that she is taking when she is refusing to settle when she was given that opportunity? Like, does she understand the opportunity that that gave her back in July with those emails? And that's what he's saying. Like, sometimes I love this right here. I love what he said right here. Sometimes positions are developed without the opponent's understanding the path being taken. That does not make them unprofessional, nonsense, immaterial, or otherwise. Queen should be awarded fees as BHB violated Illinois Supreme Court Rule 191 with her motion. Even ignoring the procedural impropriety of the motion, BHB is simply lashing out. One half of the motion is defending herself, the other half is attacking, undersigning QueenBee's need to fundraise for her defense. Other other than calling the motion nonsense and conclusionary stated as she has gone to great lengths to provide concise language and an abundance of exhibits to support the legitimate claims asserted. In the complaint, BHB makes no attempt to address the notice and demand for bills of particulars. Show why it is unnecessary. And so he cites Illinois Supreme Court rule. The signature of party constitutes a certificate by him that he has read in the pleading, motion, or other documents that, to the best of his knowledge, information, and belief formed after reasonable inquiry, it is well grounded in fact and is warranted by existing law or in good faith argument for the extension, modification, or reversal of extending law, and that it is not interposed for any improper purpose, such as to harass or to cause unnecessary delay or needless increase the cost of litigation. And this is something that I highlighted when I was reading this. BHB is proceeding pro se, but that does not excuse her from the rules. This is literally, I believe, on page 12. Okay? Page 12. And I thought this was probably out of the whole thing. I mean, everything's great, but out of the whole thing, out of everything. Ooh, let me close these blinds. You got some sunlight. I love the sunlight, but damn, that's pretty bright. Out of the whole thing, okay, right here. This is probably my favorite part. BHB is proceeding pro se, but that does not excuse her from the rule. Okay? Does not excuse you. Does not excuse you from the rule. I think that's important, right? Let's keep reading. Presented with the, and then they cite another case, presented with an opportunity to narrow the issues, BHB spent 9 pages lashing out. In doing so, she identified no authority for the motion. She provided no relevant factual support for her motion. She violated Illinois Supreme Court Rule 191, undersigned her promptly, provided an affidavit of attorney fees and costs for the court's consideration should it find Rule 137 was violated. Ooh, damn, like he's ready. He's ready. This attorney was ready. Conclusion: BHB's action within this litigation must be reined in if there is any chance of an efficient resolution on this case. The first step of this is simply getting her to provide the details sought in the form of bill of particulars. Again, he has said this over and over. Bill of particulars, Alpha David, stop it. Where's the Alpha David? Right. That's it. Just anyways, what exactly did Queen and not her co-defendants from Texas or JLR defendants in Ohio say and do that was so problematic as to support the cause of action? And what is the agreement with YouTube? That is what the notice of demand for bill of particulars requests. Once provided, then the case can advance on those issues. The motion should be denied. Ooh. Wherefore, Queen ask this court to deny the motion, find BHP violated Supreme Court Rule 137, and orders a fee and cost affidavit be filed, ruling on the paper as to the amount of any sanction and provided any relief other and provided any other relief deemed appropriate. Okay, and there's some exhibits there, and that is the one of the responses. There's a total of 3. Okay, let's see if I can bring the other one. And the other one, I don't know if I'll have time to go completely through it. Let me see. Hold up, because that was that one. This one is the redacted. Is this one it? Must be this one. This one is the opposition to motion for protective orders against Queen and request for evidentiary hearing. Now, this one, oh Lord, and it's about 8 pages, but a lot of it is I think what is making it so long is actually the body. They're like re-reviewing some of the information that's already been given before on this case. But here he is basically saying, like, first of all, yeah, no, please, no, no protective orders, and we'll go into that here in a minute. But this is the motion that requires a single question to be answered. And I love how he starts with this. He says, this is a motion that requires a single question to be answered. Can a party in a lawsuit use a motion rather than appropriate procedural process to secure a protective order for unspecific relief? Give me one sec, guys. Yeah, sorry about that. Can a party in a lawsuit use a motion rather than an appropriate procedural process to secure a protective order for unspecific relief by removing a statement from context and claiming fear from the same? If you guys remember, this is where she put my channel's name in, and she said that through my channel, QueenBee found out about this lawsuit, which is completely false. She said that QueenBee started making shirts, and I want to quote some of what was said in that. It was something about, I'm a big bitch, yada, yada, yada. We're going to make shirts. And so then what Bullhorn did, Bullhorn Betty, she decided to use that and then put that in one of her motions and basically request a protection order because there was a threat made. And I didn't see that as a threat, but hey, you know, I don't think that was a threat. Just saying. I've heard people threaten here, and that just wasn't it. That just wasn't it. But also because their hearing is supposed to be like in person, and so now girl is filing motions to make sure that it's on telephone, and the attorney returned. He said, no, we need to make it in person. That's what we need to do. So then he asked this question, which I thought was very interesting. He said, can a party in a lawsuit use a motion rather than an appropriate procedural process? Now, you're going to use them. If she wanted a restraining order, why not just file a police report for a restraining order versus doing it through the court? Why are you doing that through the court? And even the attorney calls it and he says, this is meant to cost Queen more money. This is meant to hurt Queen in the long run, right? And put in more processes and more paperwork in order for Queen to continue to, have to fight this. That's basically what it is. So he responds that by saying, of course not. The motion, along with the other filings made by BHB at the same time, are nothing more than tactics to stall and run up fees against Queen. That is what Queen's attorney has put in there. And I would have to agree with it. Yes, B. Tim. Dolly did report. Yes, the Paul Mitchell guy did report on it first. Yes, correct. He did. And there's a clip of it and I've seen it. Yes. And I think we might have some time to play it here. And shout out to Gracie. I promise you that I will read your guys' super chats here as soon as I'm done reading this. But he says, of course not. The motion, along with other filings made by BHB at the same time, are nothing more than tactic to stall and run up fees. BHB sued Queen, and when Queen had the gall to defend herself, BHB changed tactics, seeking a protective order as as she has against others in the past. Resolution of this motion can be simple and is procedural improper, and the allegations of the motions are insufficient. But if the court does not deny the motion out of hand, then Queen requests an evidentiary hearing in which BHB can be cross-examined in person. Bingo. Love it. If the court is going to allow some type of a protection order, then the attorney is saying, I want an evidentiary hearing so then I can question BHB and ask her about why she's requesting this protection order. Why is that necessary? Why? That's what he needs to do. And I want to make sure that everybody in the community that's watching this and you've donated money, this is somebody that's standing up and saying, yeah, no, you're not going to do that. And if the court allows it, then I need an evidentiary hearing so we can get to the bottom of it to determine if that's actually necessary. Just saying. My chat froze and I don't know why. All right. Hopefully you guys can see me. Let's keep going. Let's keep going. Let's keep going. So he goes into the relevant factual and procedural history. He talks about, we've already reviewed this, what happened, who, how everything started. Okay. It's all out there. We've read this. Let's see if there's anything additional to this. After Queen made her intentions to proceed, Queen began her defense on the case. She prepared and filed a notice and demand for bills of particulars, which we just, we've been talking about. She prepared and filed a notice, and because a complaint was in disarray at the time Queen filed her counterclaim against BHB, she has since served discovery on BHB, the subject to be filed motion to comply. Or compel, excuse me, motion to compel. Lord have mercy, let me get my glasses. I need to get my glasses. On August 15, 2023, BHB filed a flurry of documents. We know that. She moved to strike the notice for the bill of particulars, moved to appear on phone, moved to dismiss the counterclaims and issue a request for production, and filed the motion, began respond to. The day the undersigned explained that the bar on discussing with her would make the litigation process harder, her response was to state that she would only discuss if Queen stipulated, to relief that BHB sought. We talked about that. Okay, this is just review of what we've already talked about. Let's see what else. Hold up. The pin link above is not working. What's not working? The SWIC, your chat. The Cash App is not working. It's also in the description box if you want to copy and paste it. Is it not working? Lord have mercy. Okay, then do me a favor and you guys can go on the description box because I don't know why it's not working. It's not allowing me to hit it over here on this side. Just so everybody's aware. Okay, let me start. Argument. BHB takes defense. BHB takes offense to certain statements made by Queen and asserts Queen wishes to make a circus of these proceedings. Okay. She states she fears Queen would and will assault BHB, and for that reason she seeks a relief of order of protection with unspecific bounds. Based on the filing, Queen understands the request not to be a request for a rule, but a stalking no contact order, which is called an SNCO. Okay. BHB supplies no authority showing entitlement to entry of any protection order, let alone an SNCO. For that reason alone, the motion should be denied. The lack of authority is likely due to the fact no authority allowed the relief of BHB to appears to seek. The Stalking No Contact Order Act provides a remedy to cause offenders to stay away from them or certain third parties. To secure such an order, there must be a course of conduct where respondents follow, monitor, and observe, surveils, or threatens a person, which is nothing that Queen has done. She hasn't followed, she hasn't monitored, she hasn't observed, she hasn't surveilled, she hasn't threatened. And so the attorney is just outlining those elements for this, what is it called? SNCO. To the first two reasons the motion fails are procedural. Otherwise, At an evidentiary hearing, BHB will be unable to meet her burden. Even if they had a hearing, she wouldn't be able to meet her burden at all. Yes, Don. The attorney is calling out the BS. Okay, thank you, Vic. You just used it. Thank you, love. Like he's saying, first, the procedural is improper. Okay? Requires an independent petition or a delinquency petition. No filing was made. Second, the act requires a specific form of summons to be issued and served. No such summons was served. Third, an SNCO can only issue if stalking occurs. She doesn't have anything to support that she's been stalked. Not at all. So, and to end that, if the court is inclined to deny or disinclined to deny the motion out of hand, Queen requests an evidentiary hearing where BHB must meet her burden of proof as provided in the act. The rights to cross-examine Miss BHB in person is utmost important given her past behavior as shown by the media coverage in her own videos. Oh my God. And finally, BHB was advised of the need to secure counsel. Strike Queen's notice and demand for bill of particulars. BHB has admonished Queen to get counsel. BHB knows knowledge of the law and is necessary. Oh my God. This attorney is using the words that he has heard BHB say in the past about having knowledge of the law. Girl, he is not going to let you off. He is on your neck. Literally, he is using your words that you have said in this thing to get on you. I'm just like, wow, whoa, wow. And the chat is not moving, so everybody's aware. I don't know what's going on in the chat. Shout out to everybody. Okay. That's just crazy. That's just crazy, yo. Yeah, go ask Alex. I mean, he's just totally calling it out. So he says the signature of a party constitutes a certificate by which by him that he has read the pleading, the motion of the other documents, but that to the best of his knowledge, information and relief form after reasonable inquiry is well grounded in the fact and is warranted by existing law or good faith argument for extension, modification, or reversal of existing law, and that it is not interposed for any improper purpose, such as to harass or cause unnecessary delay or needless increase in the cost of litigation. BHB is proceeding pro se, but that does not excuse her from the rules. BHB is weaponizing Graves' laws like the act to silence her critics. In the past, she had filed a restraining order against another critic in the East Greenville, South Carolina summary court. Now, when she is being put to her proofs on her frivolous lawsuit, is attempting to run up Queen's legal bill with more frivolous filings. Y'all see that? He said he's oh my God. That is what the attorney said. Oh, wow. Here, PHB has identified no law that she was proceeding under, and the only one that might fit is it had requirements flouted. Undersigned will promptly provide an affidavit of attorney fees and costs for the court's consideration should it find Rule 137 was violated. Conclusion. For these reasons, the court can deny the motion out of hand. Otherwise, Queen seeks an evidentiary hearing where BHB can be cross-examined and put to proof of her claims to meet the standards required by the Act. Wherefore, Queen asked this court to deny the motion and find BHB violated Supreme Court Rule 137 and order a fee and cost of affidavit to be filed and rule in the paper as to the amount of any sanction, providing any other relief it deems appropriate. Oh my goodness. Okay. Okay. Yes. All right. I gotta read. Let me read these super chats, okay? Because we got whoa, and this chat is not even refreshed. Hold up, guys. I'm gonna step out and try to refresh my stream because it's like acting up. Give me one sec. Yes. Okay. I see everybody now. Okay. 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 Let me read. Oh, the super chest. Okay. SW says, Queen, close to the reach your goal. Thank you. Oh my God. Is she? Yo, this attorney is doing his work, you guys. He's doing his work. Okay. It says I have 0 people in the chat. So I don't know if I have 0 people in the chat. No, I'm glad. I'm glad to thank you. Thank you so much for the 4.99. And Kenda, you're one of my favorite creators. Thank you. Oki, thank you for the $2 as well. Everybody, thank you guys so. There's a lot of members. Shout out to you guys. Okay. I don't know why it says I only have 1 person in the chat. I don't think I do. It says I have 500 over here. You had a problem. It's probably something. It says I have 1 person in the chat on StreamYard. All right, this is the last document, and it's really a motion requiring in-person appearance. So the attorney is saying this. Listen, your telephone appearance is not going to fly. It's just not going to fly. It is not going to fly. The attorney is saying, I'm going to file a motion requiring in-person appearance of BHB on September 27th, hearing of her motion for protective orders. So he wants to see you. He wants to see he wants to see it all. I mean, why not? Here it is. Through counsel of lawyer provides this notice requiring BHB to appear in person for evidentiary hearing. Now, that is if the court says, all right, we're going to grant this protective order that BHB is placing. This is that, you're going to be in person because we got to get ready for an evidentiary hearing of what you're saying of my client. Did she threaten you? Did she do this? What did she say? Has she been stalking you? Has she been following you? No, the judge did not grant that. He's just getting the paperwork ready. Should the judge say, yes, let's go ahead and put that protection order for BHB. What he's trying to say is he's ready. He's already filed this along with everything to get everything ready to go. Should the judge say, hey, we're going to grant this protection order because we're concerned about the information out there on this petition. That's in case. Absolutely. That's in case. All right. And the chat is still frozen. So let me just say a couple things because I had to close out. Right, right, B Tim. Let me just say a couple things. I want to say a couple things. You know, I think everybody in the community should be concerned about this specific case because all cases really, especially the one with Ikamel and Upchurch, this one as well, because it affects everyone here. I think that whatever ruling happens with both cases is really going to be telling us to how we handle ourselves as content creators and what do we do moving forward. I think that's number one. It could definitely change the way in which shit happens here moving forward and how we handle each other. The other thing I want to say is this, is that I really hope if it, like, I know Betty takes everything that people say as hate. She can't listen to, she cannot listen whatsoever. But if there is something, if she would listen to one thing besides the fact that I'm sarcastic as fuck and I can be petty as fuck, because I really, really hope that she listens to this one thing. Lady, take it slow and humble yourself. It is okay. Reach out to the attorney and make this work. It doesn't have to go this far. I don't know if there's opportunity for her to figure it out. But at the end of the day, I also feel like as a community, because this kind of lawsuit shit can happen to anybody, that we should be supportive of Queen. We should be supportive of Ikamel. We should be supportive of those that are, having to fight these kinds of people and bullies that do shit to a lot of people, as well as BJ. Another example. We need to be able to stand behind people to support them. The other thing I want to say is that there's this thing called, what is it, vexatious litigant, I think that's how you say it, where somebody who willfully misuses the court resources, that is a very serious thing. And people, listen, we need to start paying attention to that shit. Some people need to be put on some of these lists, okay? Because they intentionally misuse the court resources to try to hurt people. And that's not okay over some YouTube commentator thing. That's what we do. That's what we do for a living, right? So let's keep that in mind, okay? Just saying, like, let's figure out how we're using these resources and how to move forward. But yeah, shout out to Queen, wishing her the best. Shout out to everybody. Make sure you guys are hitting that like button. And I guess we'll see what happens next. I cannot wait for the court hearing on this case because I'm telling you, I want to know exactly what happens next. Wait a minute. Good egg. Sorry, I'm not even looking at the chat. You said a real lawyer won't file vexatious. Exactly, but it's a real thing. I have known of people that get put on these lists because of like misusing the court resources to intentionally harm people and cost them money. And I hope that this is why I say this lady needs to figure out where she's going to go with this lawsuit. She can hate me, she can hate everybody. You know what I'm saying? But at the very least, if there's one piece of advice, because I have a feeling that if she doesn't fix this, it's going to land her on some list. And maybe, I don't know, maybe she needs to be in that list if she's not careful. Just saying. Sometimes you bite more than what you can chew. Shit happens, It does. All right, guys. I'm going to let you guys go. Yes. I wish I could highlight your guys' comments. This damn StreamYard is fucking up right now. It's like acting up. But I'm going to let you guys go because I got to go tend to baby buddy. You guys have a great one. I will see you guys on the next one. And please hit that like button. Bye, guys.